The Law Factor with advocate Clarence Arenas Gandawa.
The law is not a memo. It is not a circular. It is not a whispered instruction behind closed doors. Across ministries, agencies, and regulatory bodies, a dangerous trend is emerging. Directives are issued without legal basis. Circulars override statutes, and verbal orders replace written law. This is not governance. It is administrative overreach. Over to you, advocate.
Thank you, Stella. Greetings of the day. Legal hierarchy, statutes, regulations, directives, circulars. Not all legal instruments are equal. The law operates in a hierarchy, and that hierarchy must be respected. At the apex, constitutional provisions binding all branches of government. Beneath them, statutes enacted by legislature carrying full legal force. Regulations, delegated legislation, valid only within the scope of enabling statutes. Directives and circulars, internal instructions, administrative tools, not legal mandates. The principle is clear. A circular cannot override a statute. A directive cannot contradict a regulation. A verbal instruction cannot replace written law. To ignore this hierarchy is to invite confusion, non-compliance, and legal invalidity. Case illustrations: when verbal or circular instructions override statutory provisions. Jolly George and ANR. The Supreme Court of India affirmed rules and executive orders cannot override statutory provisions. Manager Eravano AUP School versus State of Kerala. Government orders imposing conditions not found in statute were declared ultra vires and unenforceable. Vijay Singh versus State of Uttar Pradesh. Executive instructions conflicting with statutory recruitment rules were rejected. Internal directives cannot occupy a field governed by legislation. These are not technicalities. They are constitutional affirmations. The law must govern, not the memo. Legal risks: ultra vires actions, institutional confusion, and non-compliance. When administrators act beyond their legal authority, they act ultra vires, outside the law. Ultra vires actions are invalid, expose institutions to litigation, reversal, and reputational damage. Institutional confusion arises when staff follow circulars that contradict statutes, procedural errors multiply, enforcement fails. Non-compliance becomes systemic when legal mandates are replaced by informal instructions. Regulatory integrity is undermined. Administrative overreach is not just unlawful, it is destabilizing. It fractures governance, weakens enforcement, and erodes public trust. Advisory note: how institutions can challenge overreach through channels. When faced with unlawful directives, institutions must respond, not with obedience, but with legal precision. Strategic remedies include judicial review, challenge ultra vires actions under administrative law and constitutional provisions. Declaratory relief: seek court affirmation that a directive or circular is invalid or unenforceable. Internal rebuttal: document inconsistencies, cite statutory authority, and request formal clarification. Legislative engagement: Advocate for clearer statutory frameworks to prevent future overreach. Institutions must not be passive recipients of unlawful instruction. They must be guardians of legality, defenders of hierarchy, champions of procedural clarity. The law moves forward, you must move with it. See you next Thursday.
Springfield Law Clinic, justice defined, rights protected. We are here to serve.